Major breaking news out of the state of Minnesota. The state of Minnesota has sought en banc review by the entire Court of Appeals for the 8th Circuit in the Worth versus Jacobson case, which deals with whether or not Minnesota's ban on 18, 19, and 20-year-old Americans being able to exercise their Second Amendment rights by carrying guns in public with a CCW, whether or not that's constitutional or not. As you may recall, the Second Amendment community won a big win in the Worth case just a few weeks ago, and now the state of Minnesota, not happy with that result, is seeking en banc review in the 8th Circuit. What does this mean for your rights, and what are the odds of it prevailing? We're going to talk about it when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. Probably should write a book on Venezuela next, although I'm not going to do that, because we talk all about that in Israel Disarmed, all the problems associated with disarming populations and government tyranny that often arises therefrom. We talk about that in Israel Disarmed. Check it out on Amazon. All right, folks, breaking news. The United States Court of Appeals for the 8th Circuit, as you know, issued a huge ruling after Rahimi. Remember, I taught you, do not buy the hype from the people that said the Rahimi decision by the U.S. Supreme Court was problematic for the Second Amendment. That was BS. The anti-gunners tried to portray it that way in the press. But if I say it's wrong, you can kind of assume that I'm right and the anti-gunners writing for the press are not correct. Rahimi is a win for the Second Amendment in many respects, but we saw that just recently in the real world. Don't trust me, trust your eyes. When the 8th Circuit Court of Appeals out of Minnesota used the Rahimi case to strike down Minnesota's 18, 19, and 20-year-old age ban on the ability to get a concealed carry permit in the state of Minnesota. The 8th Circuit used the Rahimi decision by the U.S. Supreme Court to knock out that ban that said 18, 19, and 20-year-olds could not carry guns, even though they're full-fledged American citizens. And they rejected all the historical analog laws that were brought forth by the state of Minnesota in a 3-0 decision. So what the breaking news is today is that Minnesota, rather than taking their lumps and going home, has decided to seek what's known as en banc review by the entire 8th Circuit, which is going to fail. It's going to fail. It's not going to happen, okay? So Minnesota basically asked the entire 8th Circuit to take a look at this case of Worth versus Jacobson and to reassess and to reverse the panel decision for various reasons. One of which is they said, of course, that they got the historical analogs wrong, which is not true. They tried to say that at the time of the founding, 18, 19, and 20-year-olds had restrictions on the right to keep and bear arms. But first of all, that's not accurate because the state of Minnesota has not been able to come forth with a single law that restricts the ability of 18, 19, or 20-year-olds at the time of the founding from being able to possess, use firearms. In fact, the historical evidence, even though the Second Amendment community has no obligation to do this, because as you know, once the text is implicated, the burden shifts to the government to come forth with historical traditional firearms laws to justify the modern-day gun control law. And because the text says the right of the people to keep and bear arms shall not be infringed, and we know that all Americans, part of the national community, are part of the people, which obviously would include 18, 19, and 20-year-old adults, right? They're clearly part of the people because they're part of the national community, as defined by Heller. So therefore, 18, 19, and 20-year-olds in the state of Minnesota are part of the people, which means that when you deny them the ability to carry guns in public with a CCW, you're restricting and infringing upon their right to bear arms, which means to carry arms in public in case of confrontation. So once the text is implicated by that modern-day gun control law, you know what happens. We've taught you here repeatedly on the Four Boxes Diner. The burden shifts to the government, and the government has the burden to come forth to show a long-standing historical tradition going back to the time of the founding of some sort of analogous gun control set of laws. So there is no laws on the books that restricted the ability of 18, 19, and 20-year-olds at the time of the founding to have guns or use guns. In fact, the historical evidence is just the reverse, even though the Second Amendment community doesn't have to proffer anything because the burden's on the government. But nevertheless, if you look at the historical evidence, we know that the Second Amendment was adopted in the year of our Lord, 1791. And what happened in the year of our Lord, 1792, was the Congress enacted the Militia Act of 1792. And what does the Militia Act of 1792 say? It says that 18, 19, and 20-year-olds, going all the way up to 45, by the way, are part of the national militia. And they have an obligation to do what? to actually bring their privately, listen carefully, to bring their privately owned firearms, their privately owned ammunition, their privately owned accoutrements, if you want to use that word, their privately owned accessories, including guns and ammo, with them to militia musters. They have a duty to bring those weapons to militia musters under the National Federal Militia Act of 1792. So how is it even conceivably possible that the Congress in 1792 would say that 18, 19, and 20-year-olds are part of the militia and have an obligation to bring guns and ammo with them, but somehow they don't have the right to use those same guns and ammo in their private capacity to do other things like hunting or self-defense or anything else? It's absurd, right? Absolutely absurd. And that is pretty clear what the 8th Circuit concluded in saying that 18, 19, and 20-year-olds in Minnesota have a right to carry guns and can get a CCW license. They can't be banned from doing so. That violates the Second Amendment. So why is Minnesota doing this? Here's what I think is really going on. We know that the anti-gun strategy in America has been to delay, all in the hope and prayer that a Kamala Harris, Joe Biden gets elected in 2024, and they get to either pack the Supreme Court with some newfangled anti-American, anti-constitutional court packing scheme, or they simply hope that somebody like Clarence Thomas and Justice Alito leaves the court and they get to replace them with some other progressive, anti-gun, anti-American liberal that's always going to vote against America regardless of what the law is. That is the goal. And as a consequence, there is these delaying tactics, and I think there is no way that the U.S. Court of Appeals for the 8th Circuit is going to grant en banc review in this case, in my view. It's like less than 1% chance that that's possibly going to happen. The best that Minnesota could hope for is maybe some judge will write a dissent from the denial of en banc, and that will delay things further. The reason why Minnesota may want to delay by this tactic is when you seek an en banc review from the Court of Appeals, it delays and extends your time to seek cert from the U.S. Supreme Court. So basically what's happening here in a practical sense is Minnesota is buying time before they have to seek cert from the current Supreme Court, hoping presumably that somehow the Supreme Court will change in some way between now and the time they have to seek cert. And by seeking this en banc review, it's delaying their deadline. It's extending their deadline to file a cert petition until some point in time after the 8th Circuit acts on their request for en banc review. That is, I suspect, what's really going on here, that they don't want to seek cert because they know if they seek cert with the current composition of the U.S. Supreme Court, my prediction is they're dead in the water. You have a clear precedent by the U.S. Supreme Court that 18, 19, and 20-year-olds are full-blown adults entitled to full-blown Second Amendment rights, no different than anyone else. That is my strong prediction as to what I think will happen if the U.S. Supreme Court takes an 18, 19, and 20-year-old case. And by the way, as a side note, let us assume for the sake of argument, and by the way, let me give you the argument that Minnesota is making. They're basically saying that at the time of the founding, 18, 19, and 20-year-olds were quote-unquote minors. They were minors, and as a consequence, you could deny them certain rights because they were considered minors. Okay, let us assume for the sake of argument that that historical argument is true, that at the time of the founding, 18, 19, and 20-year-olds were minors. Keep in mind, and this is how you use Rahimi offensively, meaning on the attack in support of Second Amendment rights. Rahimi points out that the law, the Constitution, is not set in amber in the same way that, for example, your First Amendment rights apply to modern technology, like you have the First Amendment right to use a telephone, to use a computer, to use a printing press, to use radio, to use televisions, things that didn't exist at the time of the founding. That's the point that the Supreme Court says that the Constitution applies to modern, can extend to protecting your activity with modern devices, modern activities. So that's what we're talking about here. So that is very good news because if you think about it, even assuming hypothetically that 18, 19, and 20-year-olds at the time of the founding had no rights under the Second Amendment because they were minors, what has happened since then? The answer is that today, 18, 19, and 20-year-olds are considered full-blown adults, with including the right to vote under the 26th Amendment to the Constitution. They have the right to vote. They obviously can engage in gender reassignment surgeries. They can engage in abortions. They can get married. They can enter into contracts. They can do all sorts of things as full-blown consenting adults at the age of 18, 19, and 20, join the military as anybody else in this country. So even assuming at the time of the founding they had fewer rights, today in the 21st century, that is no longer the case. 18, 19, and 20-year-olds are no longer considered minors today, and therefore, even assuming that the founding era history was somehow favorable to the anti-gun community, which it really isn't because of the 1792 Militia Act. But even that's were the case, because 18, 19, and 20-year-olds today are full-blown adults, and that societal changes have changed in that respect, in the same way that the means of communicating on X or on the internet or with phones or radios have changed, so too are 18, 19, and 20-year-olds viewed as full-blown adults today. So that would be an example where the law is not in amber, which the anti-gunners think is good for them, but actually, as you will see, not only in terms of protecting AR-15s, which are modern firearms, but also in terms of protecting modern semi-automatic handguns, modern firearms, and protecting 18, 19, and 20-year-olds who are full-blown adults in the 21st century. All of that is an example of how that language about the law is not in amber actually is favorable to freedom in the Second Amendment community. All right, so we'll see what happens. We'll follow this Worth case, but the bottom line is this is really a delay tactic, in my opinion, and the question is when the Eighth Circuit denies this en banc review, which I think they will, whether or not Minnesota will seek cert from the U.S. Supreme Court. I suspect they will, but again, maybe they'll just take their loss and figure it's better to lose 18, 19, and 20-year-old fights in the Eighth Circuit in Minnesota than to take it national and have a massive loss nationwide in favor of 18, 19, and 20-year-olds and another win for the Second Amendment. That'll be a strategic call that the anti-gun community will have to make via Minnesota, is my guess. But again, we'll see where things play out over the next several months. Okay, folks, hope you learned something here today at the Four Boxes Diner. Make sure you subscribe. Don't forget to follow me on X at Four Boxes Diner. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.